Well, good afternoon, everybody. This is Randy Opfer with the Air Resources Board, not BOAD. Sorry about that. I hope everybody's doing well and you're ready to get some information. I just want to give you a little bit of information about myself. I've been working with the agency for a number of years. I'm in my 28th year at the Air Resources Board. Spent a number of years in the Enforcement Division and the Compliance Division. Done a lot of enforcement. I come with a background in mobile sources as well as the enforcement. The information that you're going to be getting today deals with mobile source, and it's primarily the truck and bus regulation. But before I get any further, let's take care of a little housekeeping. With me today is Jessica Russell. You want to say hi, Jessica?
Hello, everyone.
Jessica is going to be manning the chat box on the dialog box on the side of your screen. If you have a question that comes to you during the presentation, please type it in the chat box, and she will answer the question without me knowing about it for the most part. She's going to do it kind of on the side, but if there's a question that she deems to be necessary for the rest of the class to know, then she'll read it out loud and I'll answer it to the group. All right, the other housekeeping thing is in the dialog box on the right, you also have a handout. So the handout is down just above the chat box, and it is a copy of every slide that I'm going to show you today in a nice little PDF form. Feel free to download that. If you'd like a copy of that in addition, I can always send, if you have trouble getting it, I can send you a copy, or Jessica can send you a copy. Just let us know. The last thing I want to tell you about is the fact that this webinar is being recorded. It is going to be saved onto the hard drives here at the Air Resources Board, and then we will transfer it back up to the GoToMeeting website. Once that's done, I believe that GoToMeeting actually sends you out a link for the recorded version. But if they don't, and even if they do, I'm going to come back in a couple of days after it's all been polished, and I'm going to email everybody that was registered for this class a link so that you could you can view the video at some point in the future on your own time. All right, so last bit of housekeeping is how long are we going to be here? Well, that's entirely up to the audience. Generally speaking, this class lasts anywhere from 2 to 2.5 hours. I expect that we'll take that much time and get through the material, but if we have a lot of questions, it may take a little bit longer. I normally would be done somewhere between 3 and 3:30 with the information in this class. So hopefully we'll go that direction. I don't intend to take a break because that's not a long enough period of time for me to do that. But here we go. All right, let's see if I can get this thing working. These are the topics that I'm going to cover this afternoon. We will talk and spend most of our time talking about the truck and bus regulation. I will cover the applicability and some of the basic compliance schedules. Talk about some flexibility options, and I know it says available for 2018. I forgot to change that text. It should say 2019. And also I'll talk about the closed flexibility options as well as the 2019 reporting requirements. We will go over some enforcement. I'll hit something called SB1 enforcement tool, and then I will talk briefly about tractor-trailer greenhouse gas, and if I have time, I will talk just a little bit about some funding options that may be available depending upon your circumstance. So the truck and bus regulation, this one's been around for more time than I would have cared to remember, to be honest. I've been part of conducting training and outreach for this regulation since 2009, and this rule actually was promulgated in 2008, became a law in 2008, and the first major requirements actually happened somewhere in the 2012 timeframe. As far as the rule is concerned, the first thing you need to understand is whether or not your vehicle actually falls under the rule. The basic definition of a vehicle that falls under this rule is one that is operating in the state of California, running on any form of diesel fuel with a gross vehicle weight rating over 14,000 pounds. I want to spend just a second talking about diesel fuel because I've had a couple of questions lately about that. I had someone call me up the other day and ask me, what about biodiesel? What about Jet A? What about this? What about that? And my response to any of those questions is another question. Is it running on a compression ignition engine using a diesel cycle? If that answer is yes, or the answer to that question is yes, then that is considered diesel fuel as far as we're concerned for this regulation. So because the emissions profile profile, while it might be slightly different depending on the fuel you use, it is going to have the same issues with pollutants that we're concerned with. So any form of diesel, alternate diesel fuel, or standard diesel falls under this rule. Public and private school buses are also covered by this regulation, although they have a separate path, and I don't intend to talk too much about them other than this slide. If you are a private company that owns 2-engine street sweepers, those vehicles, both engines of those vehicles, will fall under this rule. And I'm going to state this from the outset. If there are any attendees, participants, who happen to be in government service, anything other than federal government service, so that would include state, city, county, local municipalities, as well as private and public utilities, those fleets for those types of agencies are all covered by something called the Public Agency and Utility Regulation. And as such, you would not be under the truck and bus rules. So if you're listening to this presentation thinking that all this stuff covers those vehicles, I want you to stop right now, because that's a different presentation. And we do have webinars that are going to be dealing with public fleets coming up in the next few weeks. So if you're interested, please look at our calendar and you can take one of those. If you just want to hang out for a while with us, that's fine, but the truck and bus rule does not apply to the public fleets. All right, so here it is. If you, who we're going to hold responsible for this, the compliance of this rule. Obviously, if you own a truck that meets the definition I already went over, you're going to be responsible. If you lease or rent a vehicle, there is a possibility. It all is determined by the contract and the language in the contract for the lease or rental. And that is to say that if it's specified in the contract that you, the renter, is going to be responsible, then it's part of your fleet. That hasn't happened a whole lot in the state of California since this rule's been put in place, but there are some people that are doing that. They used it as a mechanism to comply with the rule without buying new vehicles. They went through rental agreements instead. Now, as far as selling a vehicle that's under this rule, California has no restrictions on selling anything you want to sell related to the enforcement of this rule. You can sell any piece of equipment that falls under this rule that you wish. You can sell to anybody you wish. There is a paragraph of text that I'm going to show you in just a second, which we are going to require you to include on the sales documentation, but you can sell it to anybody you want, anytime you want, anywhere you want. The last thing on here says California-based brokers and dispatchers. Now, here's the deal with that. If you do not actually own a vehicle that falls into this rule, but your business is to hire independent drivers and send them to different locations to do work for you, move loads that you're contracted to move, then you're considered a broker or a dispatcher. And in that case, in this regulation, as well as several other rules, you have a responsibility to determine whether or not the vehicles that you're sending out, dispatching, or brokering the use of are compliant with this regulation. Later on, I'll talk about the Certificate of Reported Compliance. That is one mechanism that some people can use and do use to determine whether or not a vehicle they're hiring is in compliance. That's not the only way you can do it, but that is one of the major ways. All right. Here is the sales disclosure. So at the bottom of this slide, it is a paragraph of text. It's actually quoted because you need to use that exact language, exactly the way it looks. It needs to be on the documentation for the sale of the vehicle. If you're going to sell it to somebody else that's operating it in California. Now, if you know you're selling it out of state and it's not to an owner that's going to operate it in the state of California, then you don't have this requirement. Me personally, I would probably put it on the paperwork anyway, just in case that vehicle comes back into the state at some point, unbeknownst to myself. In any case, this is it. If you need more exact language, there is, if you want a copy, a PDF copy, you've got it here, but we also have an advisory that has it in there. Okay. There are some exclusions under this rule, and I'm going to bring these all up just to make sure they're all there before I talk about them. Some of these are common throughout our rules. In fact, emergency vehicles and emergency use have pretty much always been exempt from most of our regulations. So have military tactical vehicles and personal use vehicles primarily are exempt. Now, there is a personal use pickup. If anybody has one of those giant ones with the big tires and all pumped up and everything, if its gross weight is over 19.5, then yes, it does fall into this rule. But otherwise, all the private use is outside of this regulatory language. Historic vehicles, the only thing I'd say about there that has confused some people in the past is the fact that the historic vehicle is not really considered historic unless it's actually registered through DMV as a historic vehicle with historic plates. You can see the picture there shows a real nice, shiny, bright, chromed up semi-tractor that's probably at a show somewhere. That is typically the kind of vehicle that we see listed as historic vehicles. If that's you, or if that's something you wish to do, then you don't have any responsibility under this rule once that vehicle is registered as such. The last thing on here was about vehicles subject to other in-use regulations. Really what I'm saying there is the fact that we typically will only cover each engine of a vehicle or a piece of equipment with one regulation. That is to say, I'm not going to have you under the public agency rule, the engine under the public agency rule, and the truck and bus rule, because your requirements only need to be one of those two rules. So if you're subject to, say, the public agency rule or perhaps the DRA's truck regulation, then you're not following the terms of this rule. You follow that other rule because that's where you are. All right. Now, one of the complaints that I get on a regular basis, or at least I have for some time, is the fact that ARB has modified this rule a number of times. And in fact, I understand that. I've seen all the modifications. I've been here for all the modifications. And the statement I usually get is, you're moving the goalpost. How do you expect us to comply with this rule when you change things around? I completely understand that. I wish I could explain to everybody in the audience how difficult it is for staff here to understand and explain some of the changes as they happen, because we're explaining it one way and then something changes. That is something we live with, because all the modifications, except for the last one, and I'll talk more about that later, but all the modifications that have happened to this rule have not been to make the rule more restrictive. They have been placed they've been put in place, specifically to allow more flexibility, more options, and more time for people to comply. And that's the case with what's on the screen right now. If you had asked me prior to December of 2010 what falls under this rule, I would have told you it's everything over 14,000 pounds diesel in California. The requirements were the same regardless of what weight class vehicle you had, as long as it was over 14,000 pounds. In December of 2010, the board directed staff to actually break that group of vehicles into two, to make it easier for what we're calling light vehicles to comply. We set up a different path for the light vehicles. I'm going to go over both these, but I just want to make sure you know that before you can determine where you fit in this rule, you have to know which category vehicle you have. Any staff person answering the phone, Jessica included here, one of the questions they're going to ask you before they can give you an answer of what your requirement is what is the gross weight of that truck? They have to ask that, because if they don't know that information, they can't give you a specific correct answer. So light vehicles under this rule are anything that's over 14,000 pounds, up to and including 26,000 pounds gross weight. That would, in industry terms, be considered a Class 4, 5, or 6 truck. The heavy vehicles are anything over 26,000 pounds, and in industry standards, that would be a Class 7 or 8. Where do you get this information? Well, most people who own vehicles know exactly where this information is, but for the purpose of making sure everybody's on the same page, I'm going to show you right here. Gross weights are something that are assigned by the manufacturer of the vehicle. They're something that does not change unless you delete or add an axle to the truck. And if that happens, whoever does that work is supposed to change this tag that came from the manufacturer. That tag is generally going to be on the driver's side door jamb. And it's going to possibly list up to 6 different weight classes, depending on the type of vehicle we're talking about. The only one that our enforcement agents are actually interested in is the one that says gross weight, gross vehicle weight, GVW, or GVWR. If you see that and then a weight below it, that is the one that you need to know. Now, as far as the other part of this rule is concerned, as far as figuring out where you fit, we also need to know the model year of the engine. And this has been confusing in the past, but not so much anymore. We've done this long enough now that I believe most people have the idea. But we're not looking at you telling us what the vehicle age is. I don't want you to tell me you have a 2008 vehicle or a 2006 vehicle. What you're telling me when you give me that information is the chassis year. That is not generally the same as the model year of the engine. And you may wonder why we focus on that model year of the engine. Well, it has to do with the fact that the federal government certifies all new engines for sale in the United States based on when they were manufactured. So if you have a 2008 truck you probably have a 2007 engine, and that '07 engine was certified by the federal government to meet 2007 emission standards. So in order for us to determine compliance rates and where you fit, we need to know the model year of the engine. Now, the only place that I know of you can find that every single time is going to be on the emission control label or the engine tag. It's also called an ECL. You see a picture of one right there on the screen on the bottom right. Now, I've had people ask me, which tag is this? Well, because there's multiple tags on a lot of engines. Frankly, I've seen probably thousands of these things, and I will tell you that every single one that I've ever seen has the same phrase at the top, and hopefully you can read it right there, but it says important engine information. If you have a tag on your engine that says important engine information, I can nearly guarantee you that that is the emission control label. It will give you the model year of the engine. It will also give you the engine family name. And those are two pertinent pieces of information as far as determining compliance and reporting. All right, so let's get into the actual requirements. And it looks like my title got messed up here. This is the light truck schedule, and it's what we call a model year compliance schedule. A model year compliance schedule is the basic requirement for every vehicle that falls into this weight class. Again, this is your class 4, 5, and 6, between 14,001 and 26,000 pounds. And essentially what this model year compliance schedule requires is you to take a vehicle based on the model year of its engine and take it out to a certain date that is set in the regulation. And after that date, on that date and beyond, that vehicle in its original manufacturer state is not legal to drive in the state of California. So let's take an example. Let's say that I had a 1999 Class 5 truck, so it's probably somewhere around 18,000, 19,000 pounds. 1999 model year engine. If you look at this chart, on January 1st of 2019, that vehicle and the engine in it were not legal to drive in the state of California, unless I had done something to it. The way this is read for most people is, actually for everybody, is that on the January 1st of 2019, or by that date, you were supposed to have converted that vehicle so that it met 2010 emission standards. I'm going to tell you straight up that that's not going to happen for most people. Converting a vehicle to meet 2010 emission standards essentially means repowering it to a 2010 engine. You're taking the old engine out, you're putting a new engine in. You've got to replace anything that won't work with that new engine, so the drivetrain probably has to be modified. The electrical wiring harness probably has to be taken out and replaced. Then you might even have to modify the chassis to get the new engine to fit, because the new engine has more equipment on it, so it probably won't fit in the old chassis very easily. Once you get all that done and it's all working and you're ready to go, because of the way the 2010 engine is built and certified, you're also going to have to make sure that the dash is compliant with the onboard diagnostics that are required for a 2010 engine. So you're going to have to change the dash lights. That process, I'm given to understand, can cost up to $70,000 or $75,000 for just a simple truck. So that's too much money for most people to even consider. The only people I know that have done this are people that have done it on their own and did it for less money than that. That was a dealership price. Or they're people who have extremely expensive chassis where repowering to a 2010 engine would actually make sense. So then you might ask, well, if I can't repower, it's too expensive, what is the choice if I have a truck that meets, this model year and it's already done? Well, the choices are repower, replace, retire, or drop down into low use. Those are really the only choices you have. I'm going to talk about low use a little bit later, so hold your questions on that. And I know there are going to be a lot of questions. But basically, when our inspectors are out in the field, the three things that they do right off the bat is they will ask the driver of a vehicle we're inspecting to open the driver's side door so they can get that weight class. Then they will ask the driver to open the hood of the vehicle so they can look at the emission control label and get the model year of the engine. And then they will take those two pieces of information, look at whichever chart matches for the model year compliance and weight class, and then they'll verify whether or not the vehicle meets the standards that's set forth in this chart. Okay, one last thing about the light vehicles, because I want to clear something up that has been a problem in the past, and that is the installation of a diesel particulate filter on one of these light vehicles. In most parts of the state, installing a diesel particulate filter on a light truck will do you no good to make the vehicle comply with this regulation. It will do you no good. In fact, it's a waste of money. Putting a filtration system on that 1999 engine just makes it a 1999 engine with a filter. It does not make it 2010 model year compliant. So you skip the filtration. I said most parts of the state because later on I'll be talking about a particular area or areas of the state where it might make sense. All right, that's the light vehicles. Let's talk about heavy. Another model year compliance schedule. You've got the same columns as far as the end and the beginning. You've got the model year of the engine on one side. You've got when that vehicle's engine has to meet 2010 emission standards on the far right. The only difference between this one and the light vehicle chart is that this one has an interim requirement to install diesel particulate filters. So that 1999 truck that I was talking about, let's say it was a heavy, class 7 instead of the class 5. Because it's in the class 7 range, it's more than 26,000 pounds, probably close to 30,000 pounds or something like that. I fit into that category where it's in the 96 to 99 model year engine. And if in order for that truck to be in compliance, I should have had a filter on that by January 1st of 2012. So I run it for 8 years, and then January 1st of 2020, that vehicle is, even with a filter, is not compliant with the regulation. It would have to convert to a 2010 model year engine. There are some flexibilities I'm going to talk about that may delay that or change that, but this is the basic schedule that we use to determine compliance. If you're following either of these schedules, then there is no requirement in this rule to actually report. Because our compliance officers in the field will, as I said, they'll check the weight class, the engine year, and then they will look at one of these charts. If you're in compliance with these charts, they're going to ask you very nicely if they can put a little sticker on the passenger side window, very low so it doesn't block the operator's view. And the reason they're doing this is because it's a color-coded sticker to let other officers know that that vehicle was inspected within a specific period of time, so we don't have to inspect it again. But in any case, they'll ask you if they can do that, and then they'll say, goodbye, have a nice day, because you're in compliance. Okay? All right. Now, there are some flexibilities that have been part of this rule for some time. In fact, there have been flexibilities in this rule since the very beginning. The flexibilities are can be based on a number of things, but generally speaking, they either extend or delay the compliance requirements that were listed in that model year compliance schedule, or one of those model year compliance schedules. They could be based on almost anything. I mean, we had ones that were based on fleet size. We had ones that are based on how you use the truck. We had ones based on how many trucks you had, all different manner of things. When this rule was first put in place, and until about 2018, there might have been 20 different options for actually complying with this rule that were outside of the actual model year compliance schedules. Now we have a lot fewer. In fact, here are some of the ones that were in the rule that have since closed, sort of. So the small fleet option was an option that was in the rule that was not an exemption. It was an allowance that gave fleets that had 3 or fewer vehicles more time to put filtration systems in and on. There's also the phase-in option that was available to anybody that had more than 3 trucks. Now, both of those expired in 2018. So there are no more small fleet options. There are no more phase-in options. So if you call our office and say, can I be put in a small fleet? There is no small fleet in this rule anymore. It's just everybody's in the rule at the point where we are. Low mileage work truck option was also one that ended in 2018. We're at 100% filtration requirement for that. Now, I'm going to spend a little bit more time talking about ag vehicles and perhaps log trucks. But essentially, those two, the reason they're on this slide under the closed period is because even though they still have requirements under this rule, you can no longer opt into them. They have been closed so that you cannot put a vehicle into these options anymore. So, and I know this is bad, but if you're a new company, you just came to California and you want to open business and you're buying all log trucks or you're buying all ag vehicles, you cannot put them into this option. You may consider them ag, but they're not actually ag under this law. All right, so let me talk about something that happened back when we made some modifications in 2014. We actually, as I said, have changed this rule 3 times. We changed it once in 2010, as I said before. We changed it again in 2013, and the 2013 amendments were codified, solidified, and more were added between 2013 and 2014. And April of 2014 was the last time that ARB actually made substantive modifications to this regulation. Our board passed it, it became law, and we were immediately sued by Lawson Trucking and the California Trucking Association. Lawson Trucking is based out of Fresno area, and they, in conjunction with CTA, decided to sue us on the basis that they thought it was an unfair business advantage for all the people who had not complied with the earlier version of the rule, because they felt that their operators had bought the filters, they'd bought the new trucks, and they were suing us based on the fact that we were giving everybody else more time, and it was competitively a disadvantage. So they actually won the case back, I believe it was late 2014, and we immediately filed an appeal. That appeal took us all the way out until 2018, and in April of 2018, the judge came back and told us we had lost the case again. So now what does this mean? This means that any of the modifications that were made in 2014 are no longer valid because the entire 2014 amendment was thrown out. And what we have to do in order to make that work, and what we're being required to do as a result of this lawsuit and the outcome, is we're being required to go back to the 2010 version of this regulation. And I'm going to tell you that there's good and bads there. Obviously, we don't like losing a case like that, but because we only put these things in to make more flexibility options available. But the good is that like at least 3/4 of the flexibility options and time that we added in 2014 had already passed by the beginning of 2018. So the lawsuit wasn't going to have any function affecting those. People who got those flexibilities got them. There are a few flexibility options that are going to have some issue related to this, and I do need to cover those a little bit more. We'll talk briefly about heavy cranes. We're going to talk about the extended use of filtered trucks, low-use ag, NOx exempt areas, and the low-use exemption. First is the heavy crane option, and this was a big deal, actually. We've fortunately been able to work something out to make this not such a big deal for those that are in it. But the heavy crane option didn't even exist before 2014. So when the rule got thrown out, anybody that opted into the heavy crane option in 2014, and I think 2015 was when they could get into it as well, they were kind of messed up because they were following a path that didn't exist anymore. And so what we did is, rather than force them back into the standards of the truck and bus rule, is we opened up the solid waste collection vehicle regulation, and we inserted this provision into that rule. It was adopted last month, and it's on its way to the Office of Administrative Law. I think we might be in one of the comment periods right now, but it's going to be going to the Office of Administrative Law unless we have any serious issues that come up. But I don't anticipate that right now, and it will be placed in that rule, which means for those people that have heavy cranes that you're not going to be following the truck and bus rule. You're going to be following the same standards that you had under the heavy crane option, but they're going to be part of a different regulation. And that's a good thing because it means there are no changes. All right, the ag vehicle extension. Again, this was an extension and kind of an exemption. It depends on how you look at it. But really what it did, this was the best provision in the entire rule. If you were able to opt into the ag provision, and the last time you could do this was January of 2015, and you met all the standards, and you've been going in there and putting your odometer readings in and holding up your end of that particular bargain, all the trucks that you got slots for were able to go all the way out till January 1st of 2023 without putting anything as far as a filtration system or a new engine in those vehicles. The only thing you had to do was maintain the low use of either 15,000, 25,000, or 20,000 miles, depending on the model year of the engine. Now, the reason that there's an issue with this as relates to the lawsuit is that in 2014, we actually changed the mileage allotment for everybody that was under the rule. Instead of being 10,000 miles per year, it went to 15,000 miles per year for everybody, all the way back till 2017. That 15,000 miles was supposed to extend all the way out till 2020. And then from 2020 to 2023, it would be lowered to 10,000 miles per year. Well, because the lawsuit ixnayed, so to speak, 2019 in respect to these mileage limitations, anybody that's part of the ag provision is only going to get 10,000 miles this year. And then going beyond, you're going to get 10,000 miles until 2023. There is one other issue that I've run across a couple of times with a couple of people that are acquaintances of mine and had some issue with this. In 2014, we added cattle trucks to the specialty ag requirement if you owned it and it was not for hire. And we also added cattle trucks as a truck that, even though it wasn't the classically defined ag vehicle, could be considered ag under this rule. Since those were added in 2014, they're gone. If you have a ag truck that was listed as a specialty ag or a cattle truck not for hire or a cattle truck, you might want to be contacting our office as soon as you can and see if there's anything that we can put you into besides that, because those are gone now. So, all right, that's ag vehicle. Now, NOx exempt. I don't know where our audience is today as far as geography is concerned, but I'm going to hope that some of you reside and live and work in the areas that are designated as dark green on the map of the screen, because that particular map shows you where you can operate a vehicle with a filter. It has to have a filter, but because of the air standards, when this rule was put in place in those areas, we're not requiring anybody that owns and operates a truck in those dark green areas to ever migrate to a 2010 or newer engine. So again, let's say I live in Siskiyou County and I transport logs in and out of the state of California up into Oregon. Well, because I'm in Siskiyou County, this rule requires you to put a filter on that truck. It should already be filtered, actually. But I'm never going to require you, the state's never going to require you to update to a 2010 engine. It's something you can do if you want, but it's not a requirement. Why this is an issue related to the lawsuit is this. You can also see some lighter shaded areas on the map. Those lighter shaded areas were areas, counties, and parts of counties that were added in 2014. So think about this. If you lived in Mono County or Inyo County, prior to 2014, you had no option to do this particular type of vehicle. You couldn't do the NOx exempt. 2014, we gave it to you. 2014 through 2018, you were allowed to operate with just a filter, even though anywhere else in the state you had to have one. And in 2018, when we lost the suit, those counties got taken away. So right now, here today, they are no longer part of this provision. It also has one other major impact, and that is this. The NOx Exempt Area provision does require filtration, as I said. It requires your entire fleet to be filtered at a percentage of the vehicles in the fleet each year going up to a certain year. We changed the schedule in 2014 to what was, it actually says current schedule. I don't know. Oh, yeah, okay. That's what it was when we changed it in 2014. Went all the way out till 2020. Now, because of the lawsuit, we have to revert back to what it was prior to the amendments. And as you can see, if you were operating for NOx exempt and wanting to put a vehicle in there, you had to have 100% of your whole fleet filtered by 2016. So today, here, now, if you want to put any vehicle in this provision, your fleet has to be filtered. Every truck in your fleet has to be filtered, except for anything you designate as low-use exempt. And this is hard for some people to understand how we make the calculation. But I had somebody the other day, and I'm going to just throw out the numbers. They had 12 trucks. They had 12 trucks. 6 of them were in low-use ag. And then they had 3 of them that were low-use exempt. And they wanted to put the other 3. So 6 were low-use ag, 3 were low-use exempt. They had 3 other trucks that did not have filters in them, and they wanted to put them in the low NOx. The first thing I told them was they have to be filtered. The 3 that you want to put in, you can't put them in unless they're filtered. But I said, before you filter them, you have to know that even though we do not count the low-use exempt trucks for purposes of this provision, we do count the low-use ag. So in order for any truck in that fleet to be put into the low NOx provision, all those low-use ag trucks would have to be filtered as well. And that's not a tenable position for a lot of people to deal with that quickly, but that is unfortunately the way the rule reads. All right. We have a couple of extensions related to filtration that you need to be aware of because in the original regulation language, we had a statement in there and a provision that said that if you were able to filter your entire fleet by January 1st of 2014, then it didn't really matter what the model year of the engine was. We were going to allow that truck to operate in the state of California until January 1st of 2023. So my 99 engine truck that I was talking about earlier, if I had filtered that prior to January 1st of 2014, I would get till January 1st of 2023 rather than the model year compliance schedule saying I was done by 2020. So I got an additional 3 years. Now, in 2014, we actually changed that provision so that it wasn't the entire fleet. It was any vehicle that got filtered in time. Well, because of the lawsuit, that is no longer the case. It's going back to the entire fleet. So there are some people that filtered that were going to get out till 2023, and no longer is that the case. All right. Let's talk about probably one of the bigger ones for most people. The low-use exemption. Now, this regulation has always had a low-use exemption provision in it. It has always had a provision that said you could go, if you stayed under 1,000 miles per year in California, then you could drive that vehicle you could keep it as long as you wanted, as long as you stayed under the 1,000 miles of California. I keep saying in California because the provision actually allowed for people that were coming from out of state. So if you had vehicles that were primarily operating outside the state of California, and you might put 100,000, 200,000, however many thousands of miles on it outside the state of California, as long as your in-state mileage was less than 1,000, you were exempt from the rule. You just had to make sure you reported the odometer readings properly. We'll talk about that in just a few minutes because there is an issue there that I've seen. We actually modified this provision a little bit, and we added to it in 2014. What we added was the fact that we added a second exemption that said you could take any vehicle up to 5,000 miles per year, regardless of where it drives. So there's no more out-of-state or in-state thing. And as long as you stayed under 5,000 miles, that vehicle would be exempt from our regulation until January 1st of 2020. Because of the lawsuit, the last year of that is no longer available. So this year, anybody that's operating under the low-use exemption is not going to get 5,000 miles. You got it in 2018, you got it in 2017, 16, and 15, and 14, but not 2019. So it's back to the 1,000 miles in California. The other interesting thing that happened, and perhaps worse for many people, is the fact that the original regulation actually limited hours of use as well. So the regulations stipulation for low use was no more than 1,000 miles in California and no more than 100 hours use in California. We got rid of the hour limit in 2014, but once again, I hate to be a broken record, but because of the lawsuit, that is now back. There are hour limits now as part of being a low-use exempt vehicle. This most likely will not affect too many people that are in this provision, but there are a large number of stationary operations like drill rigs and concrete trucks and different types of vehicles where you have hour meters because you spend a significant amount of time in stationary mode with the main engine running. You're running a PTO operation. If that's you, then you do have an issue with being low use if you're going over 100 hours per year. This provision requires that you make sure you have a functioning non-resettable odometer and you report the odometer readings on an annual basis. Now, I told you I was going to talk about something related to that, and I do want to stress something because of some issues that I've seen. I want to stress the fact that when you report your odometer readings, whether it's for this exemption or for the low mileage ag provision, there's a tab within the reporting system, and I'll show it to you in a little bit, but there's an odometer tab where you put the information for those trucks that are following these low mileage provisions. It has 3 different places to enter information. The first is the current odometer reading. So we want something in January or near January, whatever the year is. The second one is, correct me if I'm wrong, Jessica, but I think the second one is out-of-state miles. Is that correct?
That's correct.
Okay, so it's out-of-state miles is the second. So what you're going to do is put your actual odometer reading, and then the number of miles you drove out of state, if you had any out-of-state miles, goes in the second space. Then the third one is your emergency miles. Now, I really, really can't stress this enough. Anybody that is entering that information in there, before you do anything, I want you to use basic math. Get a calculator out and just make the calculation to make sure that the vehicle's non-exempt miles do not go over 1,000 miles. Because once you hit enter, guess what? It's there, and it's not going away. It's in your history file. And if you didn't make that calculation ahead of time, and the odometer reading from this year minus the odometer reading from last year, minus any out-of-state miles and minus any emergency miles is more than 1,000, the system is automatically going to make your fleet not compliant because you went over the 1,000-mile limitation. I don't know how many of those you've had, but I've had bunches of them.
Many. It's a common mistake.
Yeah, and it's I've had people who enter the decimal point one year and then don't enter the decimal point the next year. And when there is no decimal point in the reporting system, it just looks at it as you've gone like another 10,000 miles or something like that. So just be careful. That can drive you out of compliance, and the road back to being in compliance is documentation, documentation, documentation. There's no other word for it. You're going to have to prove that what you did was what you did. Otherwise, you're not going to get the low use exemption. All right. I don't mean to be on a soapbox, but I can't tell you how many times I've had to deal with that. So let's move forward. If you have questions beyond this class, okay, you can send them to the, not too many people are asking questions right now, right?
No, we haven't gotten any questions.
Okay, good. Well, that means I'm doing a really good job or you're all asleep, one of the two. If you have questions past this class, you can call somebody in our office. The 8666 diesel line is there during the week, Monday through Friday from 8 in the morning until 5 in the evening. Is that right? 5 in the afternoon? And you can call them and try and get through, and they're very good at answering basic questions. But if you happen to be after hours or you can't get through on the line, the first place I'm going to direct you to is this website that's shown on the screen. And this is what we call our truck stop. Here's the deal with the truck stop. It's been around for a few years, but it actually is a relatively new page. In fact, it's just recently been redesigned. And this is a page that is actually outside of ARB's normal web pages. It was created specifically to provide information to owners and operators about all variety of diesel regulation. And there's links in here for just about every regulation that we have on diesel technology in vehicles, mobile source, and otherwise. Some of the major ones, there's links to reporting systems. There's links to training class information, as well as the videos that I was talking about earlier, specifically any videos that we've made of these webinars, and some other videos that were made outside of webinar. That's all really good information. So I would send you here first. If you can't find what you need here, either you're not looking hard enough or we just didn't do it right. So try this before you do anything else. All right, now reporting. So I got to change the dates on this too. It should say 2018 and 2019. I don't know how you didn't catch those. In any case, it says reporting open, and technically that is still true. The reporting system is still open right now, and I can't tell you when it's going to be closed. The people I talk to that are in the know say it could go all the way till the end of February, but we just don't know. The determining factor is going to be how many people are still entering the system and how many people need to be helped. Because the truckers reporting staff are helping people on a daily basis, and they're catching up. As soon as they've caught up and they don't have any more people that are actually requesting help and needing modifications in their accounts, then they will close the reporting system to new entries. And by that I mean you will not be able to make easy modifications. You're going to have to go through the staff in order to get that done. If you buy a vehicle and add it to your fleet, you're still going to be allowed to do that pretty much any time of the year. But updating your fleet is not something that you're going to be able to do once they close the reporting period. All right. This is how you get into the reporting system. This is the actual login screen where you can create a new account and log in. You can also, if you've lost your username, actually not your username, if you've lost your password, there is a way to recover your password. I like to spend a little bit of time on this because of some other issues that I've seen. First of all, This is an automatic return, I guess we'd call it. Basically, if you have your account username and the email address associated with the account, but you cannot, for whatever reason, remember the password, you can put those two other pieces of information in here, and a password or the password will be emailed to the account on record. The reason I bring this up is because of the fact that we have a number of people that have forgotten their information, they've forgotten their passwords, and they try to go through the system only to find out that the email address that's on the account is not the one they thought it was, or they don't have the right username for the account. So the reason the email address might not be the same is because either you didn't enter the information, maybe you had your granddaughter, daughter, son, or help you do this, and they put an email address that isn't the one that you thought they put in, or perhaps you hired somebody to enter all the information for you, a consultant of some type, and they put their email address in there because they were the ones that were accessing your account. Either way, if you try to recover the password without the correct email address and the correct username, it's not going to work. You're going to have to go back and call our office and try and go through the reporting staff to get this to happen. Now, once you do log in, you should see something like this. This should tell you your fleet. It'll give you the ability to go to account settings, view or update the fleet, delete the fleet, check status. The phrase check status is where you check to see whether or not your fleet is compliant as reported. Now, if I go to account settings, this is where I can change the email address. It's also where I can change the password. You might be thinking, well, why can't I change the username? Well, the username was one that you created at the beginning. We're not going to allow you to change the username without a lot more trouble. So the username generally is going to stay the same. If you lose your username, there are ways we can get it for you. We just need to document you are who you say you are before we hand that kind of stuff out. But you can, once you're in, you can update the password and change the username. Okay. Now, other things that you can look at here, I've got them arrowed out. You can view the vehicle information. You can also view the compliance status. If we go to vehicle information, this is what it looks like. This is a list of all the vehicles you currently have in your fleet. Now, this is actually an old screenshot, so it's I think from 2016 or 2017, but I like it because it shows some information that you need to be aware of. So each line, each row represents a different vehicle that you've reported. And you can see where I've circled two things. I've circled the edit for one of the rows, and I've also circled the odometer readings tab. The odometer readings tab is where I already went over that you would enter in the current odometer reading, the out-of-state miles, and the emergency miles. And while I'm thinking about that, I forgot one thing, and it's related to emergency use for low use. I should have said this on a previous slide. I apologize, but sometimes this stuff just comes to me. We've had questions over the last several years about what constitutes emergency use. And I've always defined it, because this is what I was taught and the way it was brought to me, as emergency use is during the actual declared emergency, any mileage to that emergency, any mileage at the emergency, and any mileage going away from the emergency back home is considered emergency use. And generally speaking, that does not include cleanup. So let's say, for example, the campfire. In a traditional definition of emergency, I would say we were not currently in an emergency because we're in the cleanup phase for the campfire. However, we had to take a closer look at what the governor's declaration actually said or says. And the governor's emergency declaration for the campfire and for previous fires, we just now are picking this up, actually lists the cleanup period as part of the emergency. So right now, today, if you had a truck that was not compliant with our regulation and you wanted to do work under the cleanup of the campfire, you could do that and it would be considered emergency use. You have to be under a government contract, you have to go through the reporting period, and you have to make sure you document all those miles and you report it properly, but all those miles would be exempt from the regulation. And there are a whole bunch of, I know because I've driven here a few times, there are a whole bunch of vehicles that are not compliant with our rule at all that are up there helping in that effort. And I actually applaud them, because I think we need to help those people out as much as we can, as quickly as we can. And the more trucks and people we have working on it, the faster it'll go. In any case, let's back to the screen. So each of these rows is where you can edit an individual vehicle in your fleet, and each column represents a piece of information about that particular fleet. So when people call me up and they say, well, I can't print my certificate, what do I do? I think I've finished everything. Well, I look for a few things when I look at this screen, because I have a backdoor entrance into this. I can't make any changes here, but I can at least look at it. The first thing I look to is one of the two columns on the far right, either the PM filter or exemption/extension, or whether or not the reporting is complete. Let's go to reporting complete first. If there's a Y there, then that means that you've included all the information about that particular truck that we're asking for. If there's an N there, that means there's a missing piece of information. Makes sense. However, it's possible that if you have an N, that may put that vehicle out of compliance as well as your fleet. Because this is a fleet rule, it only takes one truck to put a whole fleet out of compliance. I had somebody who called me the other day and said, I've got 100 trucks, and over 90 of them are 2010 engine or newer, and my fleet is still not showing as compliant. So I looked at the screen, I went down through the whole thing, and what I found is he had one truck where the reporting was not finished, and all I had to do was enter a couple more pieces of information, and wingo, bingo, the fleet was in compliance. The other column on that right-hand side that I look at is the one that says PM filter, exemption, or extension. This is where you're telling us exactly what it is about that truck that makes it compliant. So you can see some of the options there. There's one that says 2016 NOx Exempt Area. There's one that says none. There's one that says PM filter, original equipment. Let's just go with those to start with. First thing, if it says none, you've got a problem, because it's more likely than not that that's what's keeping your fleet out of compliance. Now there's a comparison you should be making between that column and another one to make sure of that. The column that says GVWR greater than 26,000 pounds, if that says yes, then really under no circumstances should the PM filter, exemption, or extension say none, because there has to be something there. Even if it's a brand new truck with a brand new engine, the choice would be PM filter, original equipment. That's what's making that truck compliant, because today, all over the state of California, you need to have a filter in order to be compliant with this regulation for most provisions. If your gross vehicle weight is not greater than 26,000 pounds and there's an N in that column, then absolutely the PM filter, exemption, or extension could say none, because the light vehicles don't have a filtration requirement. You see how that works. The second thing I look for is shown fairly clearly here. It says 2016 NOx Exempt Area, and down below you can see one that says 2015 low mileage work truck. We're not in 2015 or 2016 anymore. Those should say 2019. And you may be wondering, well, why doesn't this thing just update itself? Well, because in order for it to be legal, we have to have you renew your decision to opt into whatever provision it is that you want that vehicle to follow. So back to the odometer tab, when you're entering your odometer readings, one of the things that I did not say was there that you'll see when you go there now is after all the places where you can enter the vehicle's mileage, there is a checkbox, and it says, would you like to update this vehicle to the current year's requirement? If you check that box, it will automatically insert 2019 in there. If you don't check the box, then it's probably going to say 2018. Now, that's not necessarily going to make your fleet out of compliance, but ultimately that is something that we need to be updated. All right, let's go to the next slide. I do have an example with some information in here that I wanted to go over. This is a fleet that called me last year or the year before. 4 vehicles, all ag. They had reported originally for ag, and when they came in to update their system, their compliance option says none, and they're not able to print their certificate. And they're reporting all of their trucks say not complete. And they had faithfully, according to what they told me, been coming in and entering all their information, so they didn't understand why this was this way. So I went back and I looked at the odometer reading history for each of these vehicles. And as you can see, I took this in 2015, so this is a little older than I thought, but There are 4 vehicles here, and there are odometer readings input for all 4 vehicles. You can see that they're put in for, if you look at the odometer read date, there's one put in for 2011, 2012, 2014, and 2015 for all 4 trucks. 2013 is missing. 2013 is missing. That's a problem, because the rule requires them to be under the mileage limitation for every year that they've had that vehicle in this provision. They can't have a missing year. So if you come into your account and for some reason it says none when you believe you've entered all the information correctly and you have all the odometer readings, call one of our, there is a way you can look at this data too. When you're on the odometer tab, you can click on the link for the vehicle and it will show you all the odometer readings that we have for that vehicle. So you could check it yourself, but this is something that every staff person that works on this has access to look at as well. So we can take a look and see if you have missing information. The truckers reporting system has been updated over time, and it is doing this kind of validation on an annual basis. Okay, well, let's say you fix all those things and you come back over here and you want to print your certificate under compliance status, and you go there and, gosh, dang it, look at that. It says not eligible for certificate, and you're thinking you did everything right, that we're still not going to give you a certificate. Well, first thing I want you to do is just look below where it says that. In this particular fleet, there are 14 heavy diesel trucks. It's got a total of 15 reported, which means that there's one that's not diesel. And I think on the one of the previous screens, it actually said there was a hybrid in there, so that makes sense. And then below that, it says vehicles claiming extensions 2, vehicles subject to cleanup. All 14 are ultimately subject to cleanup, but there's only 6 PM filters that are being used or available to be used towards compliance. So if you do a basic math calculation, there's 14 that need to be cleaned up, 2 that are claiming extensions, so that means I still have 12 that I need to clean up, and I've only got 6 filters. So I need 6 more in order for this fleet to be compliant. This one, it's got 2 diesel trucks, 2 reported, 2 subject to cleanup, and 2 filters. Everything's copacetic. Instead of saying not eligible for a certificate, it says click to confirm. You say, well, man, everything looks right. How come I can't print my certificate? Well, this is a legal thing that has to go on. You click to confirm, and it's going to bring up this screen right here. Essentially, this is nothing more than a legal disclaimer where you are signing your name, basically saying that everything that's in our system is true to the best of your knowledge. Because if we do not have you say this, then our citations don't have any ground. So we have to make you do this. Once you do this, you go back, and it's going to say print certificate and be a nice color green. On that, you can click that print certificate, and a window will pop up. So take your window blockers off if you want to see this. It will show you a copy of the certificate for your fleet, where you can print it out as many times as you like. You will not be allowed to save it, because at least not in the form that you can print it again with all the information, because we did at one point have people allowed to save them as PDF files, only to find that people were modifying them and handing them out to their friends. Just so you know, this certificate, and here's a picture of it, this certificate is not used to determine compliance. Our field inspectors are not going to ask you for your certificate. That doesn't mean anything to them. What they're going to do is they're going to, as I said earlier, they're going to look at the weight class, look at the model year of the engine, and then determine compliance based on what they see. You handing them a certificate doesn't do anything towards that effort. The only thing they can use that certificate for is to get your trucker's ID from, in case they have to look into the reporting system. And if they get it from there, then it's useful to show it to them. But otherwise, the certificate is only good for you to hand to fleets that are trying to hire you. It is there for a demonstration of your compliance. Remember earlier I said brokers and dispatchers have an issue with the fact that they have to demonstrate the fleets and the people that they're hiring have compliant vehicles. Well, this is one of the ways you do that, is you ask them for their certificate of reported compliance, and if they hand you one, then you've done your due diligence. If you don't do that, if you don't ask for a certificate, if you don't determine some level of compliance with this rule, and you hire the truck anyway, then what could possibly happen is that if that truck gets caught in an enforcement action with one of our officers, we'll write the owner of that truck a ticket, but we also have the ability to write the person that sent them the same ticket. So if you hired them and you didn't get the certificate from them or something that says they're compliant, you could be liable for that same citation. All right. If you want to get a little deeper in the reads as far as the regulation is concerned, we do have a standard website, one of our standard websites, that's arb.ca.gov/diesel truck. This is where all the information about the regulation is. There's compliance tools, reporting, information on retrofits, and it's a little bit, I guess, less nice than the one that I showed you on the truck stop, but all the information's there. Do we have any questions at all on truck and bus that need to be read out loud?
We have an interesting one here.
Let's go for it.
It's, are EMT ambulances exempt from this rule? That means there are no exhaust requirements for ambulances at all?
So an ambulance is an emergency vehicle. They are exempt from the rule. That is to say, one thing you need to be aware of, though, that is that if it's an ambulance that came from the factory with a filter or a DEF tank system, you're not allowed to take it off. But if it's an ambulance that doesn't have one of those, it's not required to be put on. It's out of the rule. Okay. Good question. All right, so let's talk a little bit about enforcement. As you can see in the pictures right there, we've got a truck inspection ahead. You've got some of our enforcement guys out there looking at a variety of trucks to determine compliance. The one on the far right obviously has a problem with smoke. That's a bad deal right there. But let's talk about what this is. We enforce this rule because we want to make sure as many people as possible, hopefully everybody are playing by the same rules, and that levels the field for everybody so that there's no, I guess, advantage for people that aren't following the rule. That's why we enforce it. Now, as far as who does the enforcement, it would be mainly our inspectors and our auditors. We have a whole enforcement division that is their job. We do, however, also work with other local agencies where we've hired them to do some of the inspections. I'm going to tell you there's 4 areas in the state of California that you may run into a local person before you run into a state person. The first of those would be the Central Valley of California, all the way from Bakersfield up to Modesto. The San Joaquin Valley Air Pollution Control District has a contract with us to enforce our idling limitation. Not the truck and bus rule, just the idling limitation. If you happen to go up to the North Coast, this would be Mendocino, Humboldt counties, and there's one more up there that I'm missing. But anyway, that's all the North Coast. We have a contract with the Air District in that area that's based out of Eureka, where they also enforce this rule and our off-road regulation and some of our other regulations. And the third local organization that we have a contract with is down in San Diego County. That's the San Diego County Air Pollution Control District. We have a agreement with them, a memorandum of understanding, which is a contract for them to do enforcement for us in San Diego County. There's one other place where you might run into a local enforcement person. That's in the Bay Area. We don't actually have a contract with the Bay Area Air Quality Management District, but we do know that they are enforcing this rule on their own, and they do have authority to do so. All right. We're going to talk about a few more things as it relates to enforcement. Here's the list. Let's go through them. Non-compliant fleets. How do we identify non-compliant fleets? Well, we look at DMV registration data. In fact, we're doing a lot of that right now. We also take random fleets and audit their vehicles. We have field inspectors, as I've been talking about. We go to a lot of different places all over the state of California. We also have a complaint line, the state complaint line, 1-800-END-SMOG, that people regularly call to give us information on whether or not there's a compliance issue somewhere, and we check that. Our roadside inspections, we look for a lot of different things: smoke, missing or illegible labels, tampering, illegal use of red-dyed diesel fuel. We check fleet rules, and we also look for excessive idling beyond whatever the 5-minute limitation is. I'm going to tell you straight up, though, the two things that drive most inspections in the field are, number one, is it an older truck? If it's an older truck, we want to take a look at it. Number two, is the truck smoking? It doesn't matter what age the truck is. If it is smoking, we want to see it. The reason those two things are important is we know the older trucks have the most problem complying with this rule, and we also know that any truck that is smoking is probably out of compliance, especially if it has a filter. Let's talk about the smoking, because you also need to be aware that outside the bounds of the truck and bus rule, there is a separate regulation that was put in place in the 1998 timeframe called the Periodic Smoke Inspection Program, or PSIP. Now, Periodic Smoke Inspection Program is this, and this, again, predates the truck and bus rule. It says that any fleet with 2 or more California-registered diesel vehicles greater than 6,000 pounds gross weight, where the engines are older than 4 years, must conduct an annual smoke test on each of those vehicles. They have to keep those records for 2 years, and it's not done as part of a roadside inspection. Although we do a similar test, it's called the Heavy Duty Vehicle Inspection Program, not the Periodic Smoke Inspection Program. Again, this is basically you're supposed to test the smoke coming from your vehicles each year and keep that documentation until it's asked for. Now, there were some modifications to this program in 2018. The opacity levels used to be 40% or greater, no more than 40% for any vehicle with a 91 or newer engine, and if you had an older than 91 engine, you had up to 55% opacity. That word may not mean much to a lot of people. Opacity is nothing more than a measurement of the density of the black smoke coming from the stack. The more smoke you have coming out the stack, the higher the opacity number, because it is actually a measurement of how much light the smoke actually blocks from going through. That meter that you see in the screen is actually an opacity meter. The technical term is a transmissometer, but it's just an opacity meter. So the modifications in 2018 were several-fold, but the major ones are related to the opacity levels that are allowed for these trucks. Any filter truck going forward, and this is already in effect, any filtered truck, that means truck with either a retrofit diesel particulate filter or one from the factory, is not going to be allowed to pass an opacity test where it emits more than 5% opacity. And frankly, if you have a truck that has a filter and it's putting out anywhere from 2 to 3% opacity, there's probably something wrong with the filter anyway. But we'll give you a fail if if it reaches 5% on a filter truck. If you do not have a filter on the truck, these would be your low-use trucks, whatever low-use program it's in. It's going to be a range from 20 to 40% opacity, depending on the model year of the engine. The older the engine, the higher the opacity level is going to be allowed. But nobody's getting more than 40% in the new standard. There's also going to be a smoke tester training requirement, depending on who you are and what you do. And here's the deal: there's only 2 different types. If you are conducting this test yourself using your own equipment, the equipment has to be certified and regularly calibrated, but the tester in the original rule never had to have any training to use the device. Now there's going to be an online training course that teaches you what the program is and how to do the test. If you conduct this smoke test as a business, you're conducting it for other fleets, go around and do this test. There are a number of companies that will do just this. Then we're going to require you to go to something called the California Council on Diesel Education and Technology training course. It's located at several community colleges throughout the state of California. There's either a 2-day, a 2-day training course or a single-day training course. One of them teaches you how to use the smoke tester, and it certifies you to be a smoke tester. If you're going to do it as a business, you need to attend one of those training classes. All right, I say new enforcement tool. This is actually more commonly known as SB1. And SB1 is short for Senate Bill number 1. This was also called, the long version is the Road Repair and Accountability Act of 2017. This was signed into law by Governor Brown back in 2017, and it has 2 basic requirements. Those of you who don't know what the SB1 stands for, or the Road Repair and Accountability Act language, you may more commonly be knowing this as the gas tax. So when he passed the gas tax, it does have a increase in tax on fuel across the state of California for the purposes of repairing the roads. That's the road repair side of things. But it also has a secondary part of the regulation that requires that vehicles that fall under the truck and bus rule need to be compliant with the truck and bus rule in order to get their registration, starting in January of 2020. So I don't know how many people were looking at this, but if you go back to the model year compliance schedule for the large trucks, the heavy trucks, you may notice that the 1996 to 1999 model year engines were required to convert to 2010 engines as of January 1st, 2020. That coincides very nicely with the SB1 requirement that those vehicles demonstrate they are in compliance before they're allowed to get registration. So anybody that has a 1996 through 1999 model year engine, heavy truck, is going to have a filter on it, or they'll have to be 2010 model year compliant, unless they're following a provision like the low use exempt or low use ag, in order to get their registration. Now, it phases in, starts in 2020, and it'll be fully effective by January 1st of 2023. It should be carried out. We're still working with DMV on this, but it should be carried out in such a way that if you have a 2010 engine vehicle, you will notice no difference in your ability to get that vehicle registered. If you do not have a 2010 engine vehicle, then in your registration documents, it's going to ask you for some proof that you're in compliance with this rule. You may still not have to actually do anything, because we're in the process right now of connecting our truckers database with the DMV database to allow for automatic transfer of the information between our two systems so that registration can go through without any issues. As I said, you won't have any problem if you have a newer vehicle. There's one other thing that is part of this rule that may or may not come about, and I'm only bringing it up because I've had a couple of questions about this, and that's related to language in the rule that specifies useful life for anybody with a vehicle that falls under the truck and bus rule. And the useful life clause of that new SB1 essentially says that for any vehicle that was built to a 2017 or newer model year standard, going forward, if ARB ever passes a regulation that requires turnover of that engine, the owner of that engine is going to get a minimum of 13 years or 800,000 miles before they're required to do anything. And it's whichever's longer. So if you go 13 years and you've been more than 800,000 miles, then you get 13 years. If you go 13 years and you haven't gone 800,000 miles, then you keep going until you get 800,000 miles, as long as it's not more than 18 years. This is not set in stone. By that I mean that it may never actually come to pass that ARB writes a regulation, and that clause, that useful life clause, only comes into effect if we do. And it's there as a protection for anybody that bought the new technology they were required to buy as a result of the truck and bus rule. All right. We've got some contact information here for the diesel hotline, their email, and their phone number. If you have questions, obviously, I've already told you once, but here's the information. You can call them up, and we have people who man the phones from 8 a.m. in the morning till 5 p.m. Monday through Friday.
We have an interesting question.
All right, let's go for it.
Regarding the opacity limit, there have been a lot of discrepancies between talking to ARB, different smoke testers regarding the limits. Even the smoke testers, even the smoke testers, smoke test devices are still testing at 40%. Is the new regulation final or still in review?
The new regulation, is, to my understanding, has already gone through the Office of Administrative Law and is in place. I can certainly verify that, but it went to to OAL last November, and they only have 60 or 90 days to go through it before any modifications have to be made. There is, and this may be part of the issue, there is a bill that is working itself through the legislature that may have some impact on this. I don't know as much as I should about that, but that was brought to my attention last week. So, to the best of my knowledge, to answer your question, this is in place. The opacity levels are exactly as I said. You have a filtered truck, you're not getting more than 5%, and it's anywhere from 20 to 40% for a non-filtered truck, as long as it's in compliance with the truck and bus rule. However, one statement that you made, I would like to clarify it to my understanding. You said that the units are still testing to 40%. Well, the opacity meters are going to test to any level. They don't have cut points on those. They'll tell you whether it's 0%, 40%, 30%. I believe what you're telling me is that the people running the test are still passing vehicles if they stay less than 40%. It's still being rolled out as far as enforcement is concerned, so that may be another issue. But and the last thing about that is that the training program that I talked about, the online training program, is not yet in place. So we do have some, I guess, issue with getting it all out. But as far as I know, the regulation's in place. Any other questions?
No, not any other questions like that. No.
All right. Well, let's go forward. We have I've already showed you this page. I just want to bring it up again. There's more information here, and now we can briefly. That's all the truck and bus stuff. I told you it would take the bulk of the time. That's an hour and a half that I've been talking about this, or maybe an hour. I've got 2 or 3 other topics that I want to hit. And the first one deals with tractor-trailer greenhouse gas regulation. This one's not going to take very long because the rule itself has been in place and is actually fully implemented, and there's no real enforcement issue associated with this. So this was a rule that was put in place back in 2008 to 2010, and really all it requires is for any vehicle that, any tractor-trailer combination where the trailer is 53 foot or longer, is required to, and it's a box-type trailer, is required to update its aerodynamic efficiency to meet what's called SmartWay standards. Now, SmartWay is a federal EPA program that they put in place quite a while ago. They're actually working on phase 2 right now for the manufacturers, but it's a voluntary program for manufacturers. They would get some kind of credit from the feds, if they updated and sold and certified their trailers and tractors to be more aerodynamically efficient. You may wonder why this regulation is in place. Let me tell you what's going on here. We have a greenhouse gas issue. The state of California is in the forefront of trying to work within the regulatory framework to lower the CO2 emissions coming from the combustion sources in the state of California as much as we possibly can. This was one of the very first rules that was passed, but there's a problem when you try and limit CO2 from combustion sources, because anybody that knows basic combustion chemistry should understand that CO2 is actually a product of perfect combustion. So if you turn on an engine, you're producing CO2. There's no way you cannot do that. And the more efficiently you run that engine, the more CO2 you produce. So we've been telling people for 30, 40, 50 years, produce CO2 because we didn't like the other stuff that was coming out. Now greenhouse gas is an issue, and we don't want as much CO2. Well, we're not going to tell people to operate their engines in a less efficient way to produce less CO2 because we're just backsliding on the other emissions at that point. So the only mechanism that we have for actually reducing CO2 emissions from vehicles or other types of combustion sources is by making them more efficient, making them burn less fuel. So this whole regulation, this greenhouse gas initiative, is designed to make the vehicles more aerodynamically efficient and burn less fuel. I keep this picture that's up there right now because you can see some of the equipment that's on there, those 2 little flaps that are on the bottom of the truck's trailer. Those are there specifically to help the trailers go through and slice through the air a little bit easier and better so that they're more efficient. You also have the sleeker, modern-looking type tractors, as you can see in this image, where the smooth lines of the truck are different from what they used to be. You also have, you can see right behind the cab, there's a gap fairing that covers the space between the trailer and the cab. This also aids in reducing drag on the entire vehicle. Now, this regulation, as I said, applies to any vehicle or any 53-foot or longer box-type trailer and the tractors that pull them and operate within California. If you own, lease, rent, or sell one of these, and if you're a California-based broker or shipper, then you do have requirements under this. It requires the addition of SmartWay verified aerodynamic technologies and something called a low rolling resistance tire. I'm not spending a tremendous time on dates because all the dates have already passed. If you own or operate one of the tractors that I just mentioned, it's already to the point where you're supposed to have these pieces of technology installed on them. The only way that you really get out of this requirement is if you, let me go to the next slide here, if you have a tractor that is called a local haul tractor, where it never goes outside a 100-mile radius of a designated home base. In that case, you don't really have too much of a requirement except for reporting. The same is true of short-haul tractors. Any tractor that goes less than 50,000 miles per year on the tractor itself is also more or less exempt from this rule at this point. You just need to make sure you report properly. Let's talk about low rolling resistance tires for a second, because I did mention that and I want to make sure that you're fully aware of what that means. Low rolling resistance tires are in many ways identical in how they look to a standard tire. The differences are subtle, but they are impactful. The differences will be in the tread pattern, they'll be in the sidewall pattern, they will be in the material that the tire is made of, and in all these ways, the idea is to make the tires either more aerodynamic and take less fuel to move the vehicle. So the only problem that I've seen with these or heard from anybody is that the tires cost more money. So, but if you happen to be in the spot where you meet the definitions, you've got an issue with having those on the vehicle. Now, as far as enforcement is concerned, we haven't really done any enforcement on this regulation, just minimal stuff, more demonstration than anything else. And the reason for that is because even if we had not written this rule and implemented this rule, we were getting people using this technology anyway. Because the technology actually drives, it actually works. And the people are using this, truck drivers, owners, and companies are using these aerodynamic features voluntarily, because they're saving money on their fuel costs by using the technology. So it is something that there hasn't had to be very much enforcement. All right, that's enough about greenhouse gas. Let's get to the last section of this class and talk about some funding options that you may have available to you. So there are some programs that are available for funding different types of sources. I cannot tell you specifically of a program that you meet the requirements for. I can tell you what some of them are. Currently in the state, we have a hybrid and zero emission truck and bus voucher incentive program, or HVIP, that allows you to get a significant amount of money for the purchase of something other than diesel. And I guess I should take a step back at that point, because if you really want to know where this state is headed as far as technology is concerned, and what the heads of this agency as well as the state government are looking at, they're looking at trying to go anywhere but diesel. It would be much preferred that it happens, naturally, but any monies that are available to push towards that are being used to accentuate and accelerate the move towards alternative technology. And if you don't think there's any alternative technology out there, you need to look again, because you can't believe the number of vehicles that we see in the companies that are doing fantastic things, creating new technology that is used for the same thing that these trucks are used for. But a couple things about any funding program. I mean, Carl Moyer is another example of a program, but the program's allot money based on a formula, and each program has a slightly different formula based on what its goal is for that money. But I can tell you some basics for all the programs. The first basic is that there is no funding for any fleet that's not already in compliance. This money does not pay to bring people into compliance. It pays to get additional benefit from fleets whose trucks are already in compliance. So if you have gone to the work of making your fleet compliance, but you want to go the next step, and you're a couple of years out from having to have that done, then this may be an option for you. Okay, that's number one. Number two is the money for these funding programs, practically all is going to be dispensed at the local level. Whatever air district you reside in and work in is the air district that you should go to find out whether or not you qualify. There are some air districts that have more money than others. For example, the Central Valley, the Los Angeles Basin, and the Bay Area, and San Diego all seem to get more money for these programs because the issues with air are more significant in those places. Let's see what else is there. Oh, the last thing about the money is the money varies depending on the first two things I already mentioned, but it also varies on how much use the vehicle has. The more you use the vehicle, the more likely it is that it's going to get funding. The reasoning behind that is the locals want to get as much bang as they can for the money that they're spending. So if you have two trucks, one gets 200,000 miles a year put on it, and one only gets 10,000 miles per year, you are much more likely to get funding for the 200,000 mile vehicle than you are for the 10,000 mile vehicle. All right. There is one program that is available to anybody that wants to get into new technology that does not require your fleet to be in compliance, and that's shown up on the screen. It's called the Truck Loan Assistance Program. This is not a public funding program in that it's not free money. It's a loan. It's for small businesses that operate in California, 10 or fewer heavy-duty trucks. It can be used to finance a new or replacement heavy-duty truck as long as that truck is in compliance. It doesn't have to be a brand new truck, and it's a loan with a lower interest rate than you're probably going to find anywhere else. And people that normally would not qualify for loans could qualify under this program because you're basically being co-signed by the state of California. So that is also available too. The voucher incentive program I kind of talked about. There are some requirements with the truck and bus rule that you have to meet. They're listed right here. You have to be compliant, as I said. 10 or fewer diesel trucks. 75% of your operation has to be in California over the last 2 years. And the equipment can pay for anywhere from $5,000 to $45,000 for a new or used replacement truck. There are a number of different places that you can get more information, but if you'd like to look at this, there are practically every dealership that I've had to deal with in the last several years has a person who has looked into these and can help their companies, their clients. Here's some more information and some contacts for the people in our office that actually have something to do with these programs and have more expert knowledge than I do. All right, we've got some more contacts for Diesel Hotline and Truckers Reporting, as well as the Truck Stop website and the Smoking Vehicle Complaint Line. And that's the end of this presentation. Do we have any questions?
No, none that haven't been answered yet.
Okay, so here's what we're going to do. I'm going to let me put this down here. I'm going to bring the counter back up, and I'm going to put on 10 minutes. And if you have a question, bring it up to Jessica online, and she will either answer it or she'll read it to me, and I'll answer it over the phone. But in 10 minutes, we'll shut the webinar down.